Hello everyone, my name is Amitabh Suman and today I am here to discuss the topic rule of strict liability and absolute liability of position hold in India. So the rule of strict liability is applicable as much as in India is also as in England. There is however recognition of some deviation in both ways, that is the extension of scope of rule of strict liability as well as the limitation of its scope. We can also call its applicability of strict liability and absolute liability in India. So the illustrative is all about 5 points. Number one is Motor Vehicles Act 1988. We can also call that liability without fault. Number two is Factories Act 1948. Number third is Public Liability Insurance Act 1991. Number fourth is National Grid Tribunal Act 2010. And number fifth is Polluter Pays Principle. So we can discuss one by one. So when we talk about illustrative application of strict and absolute liability in India, then we called it no fault liability. And as we know that the Indian law has recognized the concept of strict and absolute liability in a number of codified laws such as Motor Vehicles Act, Public Liability, etc. So no fault liability is a concept derived from absolute liability. It means the claimant or plaintiff need not prove the fault of the defendant. So as we know that we shall discuss the illustratives of no fault liability. So we shall discuss the number one, Public Liability Insurance Act 1991. So it came into force after the Bhopal gas tragedy and aims to provide immediate assistance to victims of accidents involving hazardous industries. Very often, the majority of the people affected are from economically weaker sections and suffer great hardships because of delayed relief and compensation. Industrial units seldom have the willingness to readily compensate the victims of accidents, and the only remedy now available for the victim is to go through prolonged litigation in the court of law. So it ensures the no fault liability against the owners of hazardous substances. We can also say that in the other words, it could be said that the owner of a hazardous substance must have insured so that any person injured or died of any hazardous substance could claim compensation without going into any question of fault on the part of the owner. So when you talk about section 3 liability to give relief in certain cases on principle of no fault, so where death or injury to any person other than workman or damage to any property has resulted from an accident, the owner shall be liable to give such relief as is specified in the schedule for such death, injury or damage. In any claim of relief under this section, the claimant shall not be required to plead and establish that the death, injury, or damage in respect of which the claimant has been made was due to any wrongful act, neglect, or default of any person. Section 4 states the duty of owner to take out insurance policies. So it states that every owner shall take out, before he starts handling any hazardous substance, one or more insurance policies providing for contacts of insurance whereby he is insured against liability to give relief under section 3. The second topic is section 140 of the Motor Vehicles Act 1998. We can also call that liability to pay compensation in certain cases on the principle of no fault, where death or permanent disablement of any person has resulted from an accident arising out of the use of a motor vehicle or motor vehicles. The owner of the vehicle shall, or as the case may be, the owners of the vehicle shall jointly and severally be liable to pay compensation in respect of such death or disablement in accordance with the provision of this section. In case of death, we compensate rupees 50,000, or in case of permanent disablement, we compensate rupees 25,000. The claimant shall not be required to plead and establish that the death or permanent disablement is respect of which the claim has been made was due to any wrongful act, neglect or default of the owner or owners of the vehicle or vehicles concerned or of any other person. So we came now section 17 of the National Green Tribunal Act 2010, or liability to pay relief or compensation in certain cases are where death of or injury to any person other than workman or damage to any property or environment has resulted from an accident or the adverse impact of an activity or operation or process under any enactment specified in Schedule 1, the person responsible shall be liable to pay such relief or compensation for such death, injury, or damage under all or any of the heads specified in Schedule 2 as may be determined by the tribunal. The tribunal shall, in case of any accident, apply the principle of no fault. Uh, it's a case of Vizag gas leakage case. We can say that it's an example of it. So now we came section 92 of the Factories Act 1948. Section 92 provides for the strict liability on the occupier for the non-compliance under the act. Section 92 provides for the joint liability of the occupier and the manager for offences under the act. The fact that the director designated as the occupier is ignorant about the management of the factory which has been entrusted to a manager or some other employee and is himself not be responsible for the contravention does not absolve him of his liability. So we now came polluter pays principle. So here say the polluter pays principle was first introduced in 1972 by the Organization for Economic Cooperation and Development (OECD), guiding principles concerning national international economic aspects of environmental policies, where under the polluter was held responsible for the environmental damage and pollution. Rio Declaration 92 Principle 16 enriched the polluter pays principle, stating that the polluter should bear the cost of pollution. So, what does the principle say? The pollution pays principle imposes liability on a person who pollutes the environment to compensate for the damage caused and return the environment to its original state regardless of the intent. Here we stand the case laws like Indian Council for Enviro Legal Action versus Union of India, or MC Mehta versus Kamal